Groovy greetings and Annalise Keatings, my legal beagles. It's your favorite neighborhood lawyer, Markwell Cade with Cade Mark Law, back with another resource for you. Today, we're going to talk about how to get away with murder. No, I'm kidding. I have a lot of clients that reach out to me and ask me, is this contract legally binding? Well, today, we're going to talk about the 5 general things you need to create a legally binding contract. Now, disclaimer alert, these are going to be the 5 things that you generally need to create a legally binding contract. This does not mean that your contract is going to be robust, complete, or even cover all the scenarios, circumstances, or provisions that you may need for your situation. As such, it's important to consult a lawyer to create a contract that fits your needs. These will be 5 elements that you can use to create something to just get you through the process. But consulting with a lawyer can help you understand other considerations that matter. For example, in some states, there are other laws that require certain contracts to be in writing. For example, in Colorado, leases that have a lease term of 12 months or more must be in writing to be a valid contract. There are other laws called the Statute of Frauds that require that certain transactions be done with a contract that's executed in writing. As such, you want to make sure that none of these circumstances are coming up for your situation. Consult with a lawyer to create a contract that really fits your needs. But if you're in a pinch, use these 5 steps, these 5 characteristics. They will help you create a contract that gets you through. The first thing you're going to need if you want to create a legally binding contract is an offer. Now, legally speaking, an offer in contract law is very similar to how it sounds in layman's terms. An offer is an exchange or promise, something that you're willing to give the other party in exchange for something else. The second thing you're going to need to create a legally binding contract is acceptance of that offer. Acceptance can take many different shapes, legally speaking, but when someone signs the contract or someone agrees verbally when you're talking about a verbal contract, when there's a shaking of hands, some type of acceptance by the other party sometimes can be just following through on the terms that the offer sets. For example, if a store offers the first 50 customers a free bag with their purchase, this means that all you have to do to accept that offer is be one of the first 50 customers. Acceptance is something that's very easy to understand, but you must have both the offer and the acceptance to have a legally binding contract. The third thing you must have to have a legally binding contract is consideration. Consideration, legally speaking, is simply a mutual exchange between the parties. Oftentimes, the offer and the acceptance and the mutual exchange or the consideration are the key pieces of a contract. If you have these 3 key pieces, so long as there aren't any other issues or implications like the contract being required to be in writing, you will often have a legally binding contract. However, there are 2 more considerations that we want to bring up and talk about today. The 4th thing you must have to have a contract that often comes with the offer and the acceptance, but sometimes can come into play when you have people that say, oh, I was joking, or that wasn't actually a real deal I was offering you, is the mutual intent to enter into the contract. This is a 4th element that's often overlooked because you have offer and an acceptance in most cases, but you must have mutual intent on both parties' behalf to enter the contract in order for it to be legally binding. If one party doesn't really intend on entering the contract, or if their heart's not in it, you may not have a legally binding contract. Usually offer and acceptance, like I said, will cover these things, but this is something to keep in mind. The final thing that you must often have to have a legally binding contract is the capacity to enter into the contract. Now, normally this mostly comes into play when you're talking about minors. When you're a minor, you can't enter into a contract with someone else, or when you're talking about someone who's mentally incapacitated or has a mental disability even. Mental incapacity can come from inebriation, being under the influence of alcohol or drugs. It can also come from having a mental disability, that requires the person to not really understand what's going on or have the ability to understand the terms of the agreement and everything that the contract is outlining. That's all, folks. Thank you so much for joining us today. This has been 5 characteristics that you need to have a legally binding contract. Notwithstanding the statute of frauds or any other laws that certain states have that require contracts to be in writing for certain transactions, we hope that this was helpful in understanding how to create a contract on your own. Of course, you'll want to seek legal representation or a lawyer to customize that contract or to add provisions that will be helpful for your situations or for things that can come up in your line of business. But this is generally speaking what you'll need to create any legally binding contract. Once again, I am Markwell Cade with Cade Mark Law, your favorite neighborhood lawyers. Protect your brand, grow your business. Stay frosty, my friends. We'll see you next time.